trouble in your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your host, Daniel. Again, I would like to thank all the new subscribers. Welcome, and thank you for supporting my channel. And if you like this content and you're not a subscriber to the channel, please do me a big favor and subscribe to this channel, and let's help the channel grow. Today is Judge Kristen Simmons. I just kind of come across her doing something. I said, I'll add her. So here we go. Yes, I will be here, but I will be muted.
DB LLC versus James Ryan Everett Jr., Keena and Everett, and all other occupants. Trial counsel appearance.
James Greenwald on behalf of plaintiff NDB LLC.
And your name, sir?
James Everett.
Okay, Mr. Everett. It's like Keena Everett is not here. Is that accurate?
She's my wife. She's sick.
She's at home sick?
Yes.
Okay, and not in the position to log in to meet and get an agreement?
Excuse me.
She couldn't log in to handle this? Because she's gonna get a default judgment against her for failing to appear.
She has COVID, so
I'm sorry, I couldn't hear you.
I said she has COVID, so that's why she has to make these appearances.
Oh, why didn't she appear on the 27th of September? She had COVID then too?
Yeah.
Oh,
She's been sick for the past almost 2.5 months.
with COVID
Yeah.
at home? It looks like there's a consent judgment here that you're entering an agreement to have judgment entered for the land contract. It says for possession, the amount due is $13,287.95. Other damages is $75. Is that part of the court costs? Is that what $75 is?
Sounds like an attorney fee.
Okay, $75 for attorney fees. Yeah, plus $133.94 for a total due $13,496.89. Less than 50% of the purchase price has been paid. And then there will be a default as to Keena and Everett. That's accurate?
Yes, sir.
Is that a yes? Okay, you understand that you have the right to be represented by an attorney? Do you want to waive or give that right up today?
Okay, yeah.
You want an attorney? You would have to hire one. Do you want to hire an attorney? Okay, and so you want to waive your right to be represented by counsel so you can represent yourself today, correct? Okay, you also have the right to proceed to a trial in this matter. You could have demanded a jury trial. You understood that right as well, correct?
Yes.
Do you want to waive that right today? Anyone threatening you to get you to waive these rights?
Excuse me?
Is anyone threatening you to get you to waive your rights? Anyone promising you anything if you give up these rights and entered into this agreement? Okay, you have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood your rights, you can return, request to have this set aside, and we'll set it for a hearing for you to explain how it was that you misunderstood your rights, okay?
Okay.
I will get you a copy of the paperwork. Any additional matters for the record, counsel?
No.
You're all set. And Docket is here. Who's on the? Who's the attorney on that one?
Herman, but Norman Whitty is, he said he's doing our Herman.
Okay. And then Troy Jones. I don't know, but it's for testing. And that's Anastasia Williams. No, I didn't put it.
Can anybody hear me?
What's your name?
Name is Troy Jones.
Okay. This is the matter of Brenda and Robert Jordan versus Troy Jones Jr. 25-04953. Council appearance, please. We can't hear you, counsel. You're muted.
Good afternoon, Your Honor. Don Keski for plaintiff. Also on Zoom is Kip Wilson from Renaissance Property Management, agent for the owner.
Thank you. The defendant is present via Zoom. This matter was scheduled for a hearing, so my understanding is that you all have resolved this matter. Is that accurate, Mr. Keski?
Yes, we have a conditional dismissal that was filed on the 15th of September.
Okay, and let's see. I have here a consent order for conditional dismissal. States that the matter will be dismissed today upon the agreement that the defendant shall pay past due rent, $1,265 plus court costs, $159.75. That's for rent due through a time period of September 30th, 2025, and that he'll pay the total of $1,424.75. Further conditions read the defendant agrees to pay all future rent payments by the first of the month of $595, starting with October 2025, with an additional payment of $500 due by the 15th of the month until the balance is paid in full. RPM to waive loss discounts and late fees that apply to tenant if all payments are made as arranged. Is that complete and accurate as to how you want to proceed, Mr. Jones?
Yes, ma'am.
Okay, you understand that you have the right to be represented by an attorney?
I do.
Are you waiving that right so you can represent yourself today?
Yes, ma'am.
You also have the right to proceed to trial. You could demand or could have demanded a jury trial in this matter. Do you understand that?
Yes, ma'am.
Are you waiving your right to jury trial?
Yes, ma'am.
Is anyone threatening you or coercing you to waive these rights and enter it into this agreement?
No, ma'am.
Okay. You have 3 business days from today's date to return to the court. If you realize you misunderstood the rights you've given up, you can request to have this set aside, and then we'll set it for a hearing. Partial performance will not satisfy this agreement, so you need to follow what you said you would do in section 3 of this agreement if you want to keep this matter dismissed. If you do not follow that, the plaintiff can request judgment to enter against you. You will not get a new court date. You understand that?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
No, thank you, Your Honor.
Okay, you're all set, sir. Thank you.
Thank you.
Okay,
You're welcome.
yep. Bye now.
Goodbye.
Thank you, Your Honor. Have a good day.
Thank you. Same to you. You know, I won't miss that. Let's see. Ms. Lacy,
Yes, good afternoon, Your Honor.
good afternoon. You are here on the matter for, is it Anastasia Williams? Did you all resolve this?
We did. We resolved it last time we were there. There's a consent judgment that I did upload. She signed it while we were there. I believe the only thing that the court requested was that we put it on the record today.
Hello.
Hello, Ms. Williams.
Hi.
This is scheduled for. I don't have a file here. That's fine. Now. No, it's fine. Got it. Okay. Let's see. This is Bill Properties versus Tron Floyd and Anastasia Williams, 25-04137. Can I have your appearance, please, counsel?
Thank you, Your Honor. Gabriel Lacey, P 79685 for Bill Properties.
Okay, Miss Williams, please state your name for the record.
Anastasia Williams.
Okay, today was the date that was scheduled for a hearing. This is a matter that was resolved. Let's see what I have in here. Okay, there is a consent order for conditional dismissal as to Miss Anastasia Williams. The matter would be dismissed today upon the condition that the matter is converted to a termination of tenancy, and the defendant shall vacate the property on or before the 10th of October and turn in the keys to the office. Is that accurate, counsel?
That is correct, Your Honor.
Okay, is that correct for you, Miss Williams?
Yes.
Okay, you have the right to be represented by an attorney today. Are you waiving your right to be represented by an attorney so that you can represent yourself?
I'm just gonna represent myself.
I can't hear you.
I'm gonna represent myself.
Okay, you also have the right to proceed to trial. You could have demanded a jury trial. Are you going to waive your right to jury trial so the matter can move forward with the conditional dismissal?
I'm just gonna move out on October 10th, like she said.
Okay. Is anyone threatening you to do that?
No.
Okay, you have 3 business days from today's date in order to return to the court to request to have this set aside if you realize you did misunderstand your rights. Lastly, partial performance will not satisfy this, so you need to move all of your things out and vacate the property by the 10th of October. Otherwise, if you don't, then the plaintiff can request judgment to enter against you. You will not get notice of a new court date, okay?
Okay, and I have 2 questions.
Yes.
The first question is, I know she said that the judgment won't go on me, it will go on Mr. Floyd.
Your device is very muffled. I have no clue what you just said.
I said that she said that the judgment won't go on me, it will go on Mr. Floyd. Okay,
at this time, the case is being dismissed against you. There is a default judgment, I'm assuming that's going to enter as to Mr. Floyd. But what I'm saying to you is that if you don't vacate by the 10th, then judgment can enter against you because that was your agreement.
She told me that. I just wanted to double check on like that end. I will be moved out on this. I will be moved out on the 10th. Probably even just before the 10th.
If you move out by the 10th, then judgment will not enter against you.
Okay.
But you got to move out and turn your keys into the office by the 10th, okay?
Okay.
You have any questions?
What about the 825? What happens to that?
What about the what?
825.
What is the 825? What is that?
The one that I put in for the motion. The money.
Oh, you have money in escrow, is that what you're saying?
Yeah, what happens to that? I'm just curious.
Your Honor, I was not aware that there was a escrow. I would ask that that get released to plaintiff so that it can be placed on past due rent.
She played escrow 825, is that what it was? Yes. Oh, I do see a note yesterday from Sybil. Okay, is that what Ms. Williams is agreeing to do? Because it wasn't what you all negotiated as part of the past due, and this was converted to a termination of tenancy.
That is correct. It was not what was negotiated. So if Ms. Williams is not in agreement, I will, I have no other recourse except to allow this agreement to enter as is.
Ms. Williams, you posted money, it's not part of your agreement, so it's up to you. Do you want us to give that to the landlord or do you want it back?
I would like it back so I can get an apartment. That would help me out a lot.
Okay, I will order it released to you.
Okay.
Otherwise, the agreement is signed. It looks like I signed it yesterday, actually. Any additional matters for the record?
Nothing further, Your Honor.
Thank you. You're all set.
Thank you.
Am I all set as well too, Judge?
You are all set, ma'am.
Okay, thank you. You have a wonderful day.
Same to you.
Bye.
Mr. Whitty, who do you have?
Mr. Hill.
Edward Rose Associates versus, is it Kenesha Chappelle or Anaya Chappelle? Kenesha. Kenesha Chappelle 25-04864. Yes, please.
Good afternoon, Your Honor. Robert Whitty appearing on behalf of Richard Herman for Edward Rose and Associates.
Okay, and we have Ms. Kenesha Chappelle here. Oh, that's right. The other defendant was a minor, correct? Yes. Okay, how are we proceeding?
Your Honor, I'm pleased to report the parties have agreed to a conditional dismissal in this case. Rent to retain is due through the end of September in the amount of $2,805. Court costs $172.04 for a total of $2977.14 to be paid on or before September 29th, 2025. We discussed that if Ms. Chappelle made that payment by that date, and the case is dismissed, it stays dismissed, there's no judgment, there's no eviction. But if she doesn't make the payment by that date or vacate, we would have the right to come back to court and request the court to enter a judgment and order of eviction, and that would happen without notice or further hearing. Partial payment would prevent that from happening. We also discussed her rights under MCR 4.201J, after which she signed the conditional dismissal if I may approach.
Thank you. Okay, and Ms. Chappelle, that's how you want to proceed, correct? You understand that you had the right to be represented by an attorney?
Yes, I was wondering, I was supposed to talk to an attorney, but for some reason, I wasn't able to call me or anything, but.
I'm not sure, but are you going to waive your right to an attorney so that you can have this conditional dismissal move forward today? I'm sorry?
Sure, yes.
Okay. You also have the right to proceed to trial, and so you could have a trial, you could have demanded a trial, or you could have a non-jury trial, at which point you would present any defenses that you believe you have to withholding the right. You understand that? And you want to waive your right to trial, ma'am? Is anyone coercing you to give up these rights? Okay, and so you will pay the past due rent, $2,977.14. That includes court costs on or before the 29th of this month, correct? Partial performance will not satisfy this agreement. So that means that if you don't pay that amount, the plaintiff can request judgment to enter against you. You will not get a new court date. You got to pay that amount by the 29th, which is the date that you agreed. You understand that? Yes. Do you have any questions at this time? going to get a dismissal as to the minor. I don't know why people file things with minors' names on it. Because you can't default her.
Nor am I requesting, I didn't know there was a minor since, of course, I'm just covering this for Mr. Herman.
Yeah.
I think what happens is they show up as occupants on leases and sometimes you can name all the occupants. It's like, well, I don't think you want to give a record, a legal record for a minor.
I'm not giving a legal record for a minor because a minor can't enter into an agreement.
Right. No, I agree with you.
So I'll get a dismissal for the minor.
Thank you.
So the civil department won't reach out as to what's going on there. And then you will get your copy of that paperwork in just a moment, okay?
Thank you.
Thank you.
I've got
There's
one
someone
on Zoom
online.
and I've got one in the hallway, so I'll deal with Mr. Deng in the hall and then I'll come back and pick up.
Well, the one on Zoom is ready to go, correct?
I have not talked to Ms. Tackett. So I've got to talk to both of them. If Tackett is the one on Zoom.
I am here, Your Honor.
Gave permission to. Yeah, the pretrial, but it wasn't supposed to be a contested hearing. Got it, okay. It was supposed to be resolved, is that what? Got it, okay. Thank you.
Okay, so I'll deal with him in the hall as quickly as possible.
Am I supposed to be talking right now, Your Honor?
Not unless there's someone in there for you to talk to, and Mr. Woody has not logged on yet.
Okay, thank you so much. Sorry.
No problem. Okay, on the record in the matter of Edward Rose Associates versus Jacob Dang, 25-04872, appearance.
Good afternoon, Your Honor. Norman Whitty appearing for Richard Herman on behalf of Edward Rose Associates.
And you're Mr. Dang? Is that correct? Okay, today was the date that was scheduled for a hearing. We do have a consent order for conditional dismissal. It says the case will be dismissed today upon the condition that you pay the past due rent plus court costs for a total due $760.29, that you'll pay that on or before September 29th. Is that accurate?
Right.
Okay, you understand that you had the right to be represented by an attorney?
Yeah.
Do you want to waive that right and represent yourself today? You have the right to proceed to trial. You understand that?
Right.
Do you want to waive your right to trial to have this consent order for conditional dismissal entered today? Is anyone threatening you to do that? No coercion to get you to do that? Yeah. Who's coercing you?
Huh?
Is
Oh,
anyone?
no.
Okay. You have 3 business days from today's date to return to the court. If you misunderstood your rights, you can request to have this set aside. Lastly, partial performance will not satisfy this. So if you don't pay the full amount by the 29th, you could be removed from the property and judgment will enter against you. There will be no court date provided to you. You understand that?
Right.
You have any questions?
Yeah.
Any additional matters for the record?
Nothing plaintiff, Your Honor. Thank you.
Okay, you're all set.
I would say it'd be pretty hard for me to coerce this gentleman.
I was gonna say, I don't know what you're saying. Is that Ms. Alexander? Yes. Okay, this is Fountain Place versus Deasia Alexander, 25-04717. Council Parent.
Good afternoon, Your Honor. Robert Visconti, P617564.
There was a date that was scheduled for a hearing for non-payment of rent. Did you resolve this?
We did, Your Honor. We have a proposed consent judgment. Court's consideration.
Put the terms of the record.
Your Honor, this is a judgment for possession only. Rent to retain is $718.54. Costs are $176.54 for a total redemptive amount of $895.08. We've agreed that an order of eviction will issue if Ms. Alexander does not make her payment in full by the end of the day on September 30th. And to explain her rights pursuant to Chapter 201J, and we do have an order prepared that's signed by both parties.
You didn't already do a consent judgment on this? Or we attempted to?
We attempted to, and we did.
Got it, okay. This in my notes said that we did one. Okay.
Approach.
Okay, so you're ready to do the consent judgment today, correct? Yes. You understand your right to be represented by an attorney? Yes. You want to waive that right?
No.
You want to get an attorney to represent you?
Oh, no.
Okay, so then you're waiving the right, correct? To represent yourself. You also have the right to proceed to trial. You could have demanded a jury trial. You understand that?
Yes.
You want to waive your right to trial? Or do you want a jury trial?
No, I want to wait.
Okay, so the matter is resolved by your consent to judgment against you in the amount of $895.08. You'll pay that or vacate the property by the 30th of September, correct?
Yes.
You have 3 business days to return to the court. If once you leave here, you realize you misunderstood your rights, you can return and request to have that set aside, okay? Do you have any questions?
No, I don't.
Any additional matters, counsel?
Not further, Your Honor.
We'll get you a copy of the paperwork.
Okay.
I'm back, Your Honor. I'm just waiting for him to come back into the courtroom as well.
It's on the camera. Yeah, you get a bill in the mail.
Yeah, Sean.
Sent it.
Yeah.
Okay, this was Ms. Tackett that you have?
What?
Ms. Tackett? you
Yes.
ready on? Okay, on the record in the matter of Edward Rose Associates versus Haley Tackett, 25-04863, counsel appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of Richard Herman for Edward Rose Associates.
Okay, and Ms. Tackett is present via Zoom without counsel today. How did you all resolve this?
Your Honor, I'm pleased to report the parties have agreed to a conditional dismissal as follows. There's rent to retain in the amount of $2,349.67 through the end of September. Court costs are $172.04 for a total of $2521.77 to be paid by September 29th, 2025. Ms. Tackett indicated to me that I think her intention is to vacate the unit, and I explained that since this is a possession-only case, she can satisfy the conditional dismissal either by paying that amount or just by turning in keys by the end of the business day on September 25th. We discussed that partial payment wouldn't prevent us from getting an order of eviction. If she didn't either move or turn in keys, then we would have the right to come back and get a judgment and order of eviction without further notice. We discussed her rights under MCR 4.2015, MCR 4.201J, after which she indicated that I did have her permission to sign the conditional dismissal on her behalf, which I'd like to confirm on the record.
Thank you.
Yes.
Thank you. Okay, Ms. Tackett, what Mr. Woody said is accurate as to how you want to proceed.
Yes, Your Honor.
So the matter will be dismissed today upon the condition that you either vacate or pay the past due rent, $2,521.71 on or before the 29th of September, correct?
Yes, Your Honor.
And you agreed that you gave permission to sign this on your behalf, correct?
Yes, Your Honor.
Okay, you had the right to be represented by an attorney. Are you waiving that right to represent yourself today?
Yes.
You have the right to proceed to trial. You could have defended a jury trial. You understand that, right?
Yes.
You want to waive your right so that the conditional dismissal can be entered today?
Yes, Your Honor.
No one's coercing you to do this, correct?
No, Your Honor.
So you have 3 business days from today's date to return to the court. If you realize you misunderstood the rights that you've given up, partial performance or partial payment will not satisfy this. So you either need to pay the full amount or vacate and turn over your keys, leaving the property in broom swept condition by the 29th of September, okay?
Yes, Your Honor.
Any additional matters for the record, counsel?
Nothing for plaintiff, Your Honor. Thank you.
You're all set, Ms. Tackett.
Thank you. Have a wonderful day, guys.
Thank you. Janae Bertley?
Yes, I can.
Okay, today was the date scheduled for a hearing. This is for non-payment of rent. I do have a consent judgment. It states that your consenting to judgment against you for the amount past due $5,297.25 plus court costs of $258.79 for a total past due $5,556.04, correct?
Yes.
It also looks like there is money judgment entering at this time or no?
Yes, I actually checked. Crossed
Well,
out.
then
It
you crossed
was,
it out, so.
yeah, it was requested in the complaint and the money judgment is prorated as of today's date, the 17th.
Okay, so money judgment will enter in the amount of $5,144.37, correct? Okay, you have the right in this matter to be represented by an attorney. Did you understand that right?
Yes.
Are you going to waive that right to represent yourself?
Yes.
You also have the right in this matter to proceed to a trial. You could have demanded a jury trial. Do you understand that?
Yes, I can.
You want to waive your right to trial? Do you want to have a jury trial on this or a non-jury trial? Do you believe you have a defense to why you didn't pay the rent? You're not sure? Okay, so you wanted to have a hearing on this or a trial and share something with the court?
No, not really, because it wouldn't really matter.
What is it that you don't believe matters?
What I gotta say, like, the amount is just due.
What is it that you believe doesn't matter?
Even if whatever I say, the amount is still gonna be due.
I don't know. Was there an issue with the condition of the property?
No.
Was there another issue?
No.
Okay. Okay, so it was a personal issue as to why the rent wasn't paid?
Yeah.
Okay, and so you're seeking some assistance from some agencies or something?
I tried, yes. I got denied.
Okay, so you understand that you either have to pay this past due amount or vacate the property by the 29th of September, correct?
Yes.
And no one's coercing you to enter into this consent judgment, correct?
No.
No one's forcing you or promising you to do anything correct?
Correct.
Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood your rights, you can return to the court and request to have this set aside, okay?
Okay.
Do you have any questions for the court at this time?
No.
We'll get you a copy of that in just a moment, okay?
Okay. Best
wishes to you, ma'am. This is LG Park Place versus Michelle Fisk and all other occupants to 5-04-883 appearance, please.
Good afternoon, Your Honor. Jeff Luke appearing on behalf of plaintiff.
Okay, what's your name, ma'am? Yeah, what's your name?
Michelle Fisk.
Okay, today was the date scheduled for hearing. I do have a consent judgment here that says that you're entering consent judgment where past due rent is owed a total $8,071.86, correct?
Correct.
That includes court costs, and that there's a money judgment that will enter in the amount total $7,540.16, correct? You understand that you have the right to be represented by an attorney. You want to waive that right and represent yourself. You also have the right to proceed to a trial. You could have demanded a jury trial or you could have a non-jury trial. You understand that? Do you want to waive your right to trial? Okay, and is anyone coercing you to enter into consent judgment?
No.
Any promises if you enter into consent judgment?
No.
You have 3 business days from today's date to return to the court and request to have this set aside if you realize you did misunderstood your rights. Otherwise, you have to pay the full amount due, $8,071.86, or vacate by the 29th of September, okay? We'll get you a copy of the paperwork. Any additional matters, counsel?
No, Judge.
Thank you. This is the matter of Victoria Arms LLC versus Eleanor Kent and all other occupants to 5-09-04944. Appearance, please.
Good afternoon, Your Honor. Nicholas Darlinghouse on behalf of the plaintiff.
And ma'am, your name? Lenore Kent. Okay, today was the date scheduled for a hearing. This is for non-payment of rent. I do have a consent order for conditional dismissal. Says the matter will be dismissed today upon the condition that you pay the full amount due plus court costs of $4,729.12. That's for rent due through a period of October 13th, 2024.
Yes, Your Honor. Rent's due on the 14th of each month on this lease.
It's not 2025.
Oh, oops.
Okay. We'll change that to 2025. I just wanted to make sure I didn't miss anything.
No, that was you.
Okay. It says tenant shall pay $700 by the end of the day on Thursday, September 18th, and $800 each Friday thereafter, beginning September 26th, until balance is paid in full. Correct, ma'am? You understand that you have the right to an attorney? You want to waive your right to an attorney and represent yourself. You also have the right to proceed to trial. You could have demanded a jury trial. You understand that? You want to waive that right as well? Is there anyone threatening you to do that? Anybody coercing you to waive these rights? Partial performance will not satisfy this. So if you want to keep this dismissed, you have to do exactly what you said you were going to do on section 3, which is pay those amounts on those dates. Otherwise, judgment can enter against you. You will not get a new court date. You understand that?
Yes, sir.
All my pens are. Again, you have 3 business days to return to the court. If you realize you misunderstood your rights, we'll get you a copy of this paperwork and you'll be all set, okay? Thank you.
Thank you, Your Honor.
No problem.
How are you? Just Ron Mark, see if Mr. Bevel comes.
For Devlin,
Yeah.
they have anything ready to go? No?
No, he's about to go back up there and talk to you.
Yes, and Mr. De Leon, that's how you want to proceed, correct? You understand your right to be represented by an attorney today? You want to give up that right and represent yourself?
No, ma'am.
You want to get an attorney?
Yes,
Okay, are you going to hire that attorney?
no, ma'am.
Okay, so how are you going to get an attorney?
Court appointed if possible.
This is not a criminal matter. We don't have court appointed attorneys for landlord tenant.
Understood. Then, well, I would like to, the first option being transparent.
Represent yourself? Okay, you also have the right to proceed to trial. You understand that, right? You want to waive your right to trial in order to have this move forward in the consent judgment form?
Yes, ma'am.
Okay, no one's forcing or threatening you to do that. Is there?
No.
Okay, no promises if you waive your rights and enter into this consent judgment agreement?
Yes, ma'am.
What was the promise?
It was to pull the money. I'm sorry, what's the-
Anybody promised you anything to get you to waive your rights and do a consent judgment?
No, ma'am.
Okay, so you'll, judgment will enter today where you pay the past due rent plus court costs, $2,765.64, on or before, the 29th of this month, correct?
Yes, ma'am.
You have 3 business days to return to the court. If once you leave here, you realize you misunderstood your rights, you can return and request to have this set aside, okay?
Yes, ma'am.
We'll get you a copy of the paperwork in just a moment. Do you have any questions?
No, ma'am.
Any additional matters, counsel?
No, Your Honor, thank you.
You're all set. Counsel, which matter do you have?
Pennsylvania Flats versus Andre Robinson.
Are you ready?
Yes, Judge.
Okay, this is file number 25-05121. Appearance, please.
Sunshine Hart, 69542, behalf of plaintiff.
And RJ Robertson is present?
Yes, Judge.
Yes.
Okay. Today was the date scheduled for hearing. This is for non-payment of rent. What's the agreement?
Your Honor, we have a consent whereby the rent retained possession is $400. Court cost amount $175.45. Total redemptive amount $575.45 with a pair vacate date of September 29th, 2025. I did advise Mr. Robertson of his rights under the court rule, and he executed the consent judgment. If I may present it to the court.
Thank you. Mr. Robertson, you understand your right to be represented by an attorney?
Yep.
Do you want to waive that right and represent yourself?
Yep.
You also have the right to proceed to trial. You could have demanded a jury trial. You understand that right? And you want to give that right up as well? Is that a yes?
Yes.
No one's forcing or threatening you to do that?
No one's forcing.
Okay, you have 3 business days to return to the court. If once you leave here, you realize you did misunderstood your rights. Otherwise, you'll pay the past due amount plus court costs, $575.45, or vacate the property by the 29th of this month, okay?
Yeah.
We'll get you a copy in just a moment. Any additional matters, counsel?
No, Judge. Thank you. That concludes it for the cost docket today. Have a great day.
Same to you. Mr. Dar is here. We have not seen Shay Thornton yet. Oh, are you ready already? Oh,
I can go check.
you haven't had a resolution.
I spoke to her lawyer and then I said, hey.
Oh, she has a lawyer?
She has a lawyer. Supposedly.
And Sierra Oliver, P 87707 for the defendant.
Today was the date that was scheduled for hearing for non-payment of rent. How are we proceeding today?
Yes, Your Honor, we have had a chance to talk to the plaintiff here. We were not able to reach a resolution today. However, I think that there is a dispute. There are some significant accountability issues. And I think that there is a dispute about notification and how much Mr. Dowrick knew and the remediation efforts that he went through. So at this time, the defendant would request a period of 30 days of written discovery.
You want a period of 30 days for what again?
For a period of written discovery.
Okay. Is there a counterclaim on this? Have you filed a counterclaim?
Not a counterclaim, just an answer, Your Honor.
Okay. No jury demand?
No, ma'am, or no, Your Honor.
When your request is granted, we'll get your new date.
Thank you, Your Honor. I do have a proposed order here, if that's something. Yeah.
Yes. Yeah, you can set it for the hearing date. Is that good, huh?
No, we don't.
Was that on relative again? I mean, what's the next available one? I know. January. How is that the next available? Maybe it's just January.
We pick the holiday.
Holiday.
And
Thank you
then
very much.
one that we would have had, we have to do, that's a raise. We have to do the Cannon's raise that day. She's out.
So they took my hearings?
So we have to do, unless you want to do hearings. in the
No, I'm saying, we were supposed to have hearings, but they
Yeah.
said, got it.
Yeah. So that would have been the 30 days.
And that, we don't have, so we're not having any hearings anymore this year?
This would be maybe like, find another civil day and just change that to the.
Oh, you can do that. You can find a civil day.
Yeah.
This sounds like we don't have any more LT hearing slots for the year.
We can do the October 14th.
Does October 14th work?
That is just a tad bit less than the 30 days for discovery.
That is less.
I'm also, my due date is also October 17th, so just in case, like.
Oh, there you
Reminded me.
Oh, you can't come.
But if I'm still not given birth,
No.
yet, I will.
We don't want you to go on labor here. Yeah, it's just because the way everyone's schedule is working out, and then the holidays, looks like Wednesday's a bad day for us. Up to
Change this ordinance day to a LT day. November 18th.
November 18th. At what time?
We can do 1:30.
At 1:30. Any additional matters for today's record?
Nothing further.
Did you say November?
November 18th
November 18th.
at 1:30.
Does she have to put something in, any rent in escrow?
You can file an escrow, a request for escrow.
at this point, she owes monies from June, so it's getting up there.
I recognize that. You can, there may be paperwork over there. If not, someone, you can file a request for escrow order for me to review and sign. And so she could put money in escrow. The court will decide how much that should be moving forward. It looks like she's alleging a habitability issue, which may or may not be a defense to why she withheld the rent. But to show good faith, she'll be ordered to put money in escrow. Any other requests? Okay, I think the paperwork should be over there.
Yeah.
Nothing's over there. Not for the escrow, that's civil. Oh, we gotta go down to civil for escrow. Yep.
Yep.
Okay, any additional matters? Okay, you're all set.
Thank you very much.
Then we have Andrea Will, and then Tribal Young. There's Oliver representing Young though.
Yeah.
Have we seen anybody from Burkhart?
So Garland House City is represent, he's gonna be with Burkhart, we need to find out what's going on.
Things and dates scheduled for hearing for non-payment of rent. Have you all come to resolution on this at this time?
Yes, Your Honor, we have agreed to stipulate to a 2-week adjournment to allow my client's SCR application to process.
Well, that we have 2 weeks, but we just have a reading.
Or whenever the court schedule will allow.
Yeah, October 8th at 3:15. October 8th at 3:15. Any additional matters for the record?
Nothing for me, Your Honor.
Nothing further, Your Honor. Thank you.
You're all set.
Thank you.
We see Andrea Wills. Is Andrea Wills here?
Oh, shit. Sorry.
Do you mind if we take a moment to?
I'll take your time.
Thank you.
I want to know, have you made this mistake?
Okay, let's see. On the record in the matter of the city of Lansing versus Deshauna Ebright, 250-297-9372. Appearance, please.
Elizabeth Cardinal, on behalf of the City of Lansing. Assistant Public Defender Justin Straub on behalf of Ms. Deshauna Ebright, who I do believe is here via Zoom.
Ms. Deshauna Ebright, are you present?
Yes, ma'am.
Please start your video. Okay, so I have file number ending in 71 and 72. There's a driving and registering and no insurance. Was this resolved?
Your Honor, I'll defer to defense. No, Your Honor, it is not yet resolved. Ms. Ebright has asked, will ask the court for additional time to get her insurance registration. Yes.
March 23rd at 10. March 23rd at 10.
Okay.
Do you have any questions for the court?
No, ma'am, I'm just in the process of figuring out the insurance. No.
Sounds good. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Nothing further. Thank you, Your Honor.
Thank you, Ms. Ebright. You're all set.
Thank you.
You're welcome. Is Whitney Houston here?
I believe we reset that
Oh,
this
we did
morning.
it already. Okay. Jenkins was reset. Maria Wallace is here. This is City of Lansing versus Maria Wallace, 18-00253. Appearance, please.
Elizabeth Brooklyn on behalf of the City of Lansing.
Assistant Public Defender Justice Strong on behalf of Ms. Mariah Joe Wallace. Who is here via Zoom.
Okay, this was the matters set for the sentencing for income tax. Or failure to pay income tax. Let's see here. How are we resolving this?
Your Honor, the city's request would, unless there's any bond that can be applied to this, the city's request would be that any remaining balance be transferred into restitution.
I'm sorry, this is a pre-trial. I don't know if I said sentencing. This is pre-trial for income tax. So she's gonna be doing what?
Well, the discussions have revolved around converting her bond, if there is any, into restitution for the outstanding tax violation.
What is she gonna do? She's gotta plead to something. You just can't convert bonds.
Oh, she would plead to the violation.
She's gonna plead to all counts of it's multiple counts. So with the, and is there a deferred sentence? Like what's going on? Just it's 7 counts. I don't know how much the restitution is. It looks like there was a bond 3,010%. She's in custody, correct? In Florida.
Yes.
Where was bond posted?
The 3,000.
Yeah, she hasn't posted bonds. That's what I was trying to understand why we're talking about a bond. She's in custody, so I don't see how she would post a bond. She was arraigned from custody, because that's what it says here, that defendant is in facility in Florida. That was canceled.
I apologize, Your Honor, maybe I may be misunderstanding this. I have a bond set 10% deposit in 2018. But when is she supposed to get out? Do you know?
But that was a bond that she failed to appear, because that would have been forfeited a long time ago.
Okay.
Yeah, we're gonna forfeit it again. She's not on bond on this at this point. She has a new bond, which is 3,010%, and she's not posted it.
Your Honor, my client is amenable to rectifying the situation. Understandably, under her circumstances, she's limited in being able to make any current cash payments on the balance.
How long is she in custody in Florida?
Ms. Wallace? How long?
Yes, I have a 120-month sentence. I was sentenced July 2nd of 2025.
Continue. So she's gonna plead guilty? is what you're saying?
Well, actually, Your Honor, we're discussing a deferred sentence.
How?
Well, that was before we knew how long she was gonna be.
That could have been the first question. I think that the public defender should ask, say, how long you gonna be in, she's in prison. She's not in jail. It actually says it in here. 2033 is what the magistrate put in here. So the only option she has is to plead guilty. And because we wouldn't even be able to have a trial on this, and look, she has, obviously, we can't force her to plead guilty. She could demand a jury trial, then that would put it back on them. They have to figure out what they want to do after that. Because we can't rid her here for failure to pay income tax.
Do believe we will pursue that route.
Which route?
Demanding a jury.
Do you need $300, $500, or even $1,000 fast? WeFixMoney.com is your #1 trusted source to get money for.
And this was, it was difficult. I think this was one of the facility was adamant about. Adamant about a test call for today, so I guess that worked out. I'm sorry?
I said they never did it, but it worked.
Right, okay. February 23rd at 8:15. February 23rd at 8:15. We'll set up a jury trial on February 23rd at 8:15. At this point, obviously, we're not sending any writs to get her here. I'll leave it to you and the city to work out how this is going to be resolved between now and then for that date and time in question. We'll have her rated for video for that date, okay?
Thank you, Your Honor.
Ms. Wallace, do you have any questions today?
Not right now, no, thank you.
Okay, any additional matters for the record?
No, Your Honor, nothing further. Thank you, Your Honor.
Thank you. You're free to go, Ms. Wallace.
Okay, so will I be hearing back from my attorney
Yes, ma'am.
before the 23rd?
Of February, yes.
Okay, and what, is the warrant still open for me now, or is that cleared?
You're not in warrant status, but you still have a case pending.
Okay, thank you so much.
You're welcome.
And in God.
Stop it.
This is Aspen Flats versus Jean-Marie Yahoo, 25-06283.
Good afternoon, Your Honor. Attorney Carrie Zanon on behalf of plaintiff.
Okay, I did see Jean-Marie. I don't know how to pronounce the last name. We were supposed to have an interpreter, or there was not an interpreter here. I don't even see that one was requested. This was set for hearing in my absence. It was handled by another judge in my absence. There was a request for a writ. It's stated in the request that $2,500 had been paid and the judgment amount was for $2,550 and some change.
That's correct,
And
Judge.
so the judge said it needed to be set for a hearing because virtually the entire amount had been paid.
Understand, Judge.
So I'm assuming this the remaining $50 not been paid.
It has not, Judge. Since the 2,500 was paid and payment was made on November 20th of 2025, nothing has been paid towards the judgment at that point or any other rents that have come due.
Okay, well, I can only address the judgment at this point.
Understand.
And I can't even properly address it because they did not request. I don't know why the clerk's office set this and did not request an interpreter. So I see the defendant here, but I don't know that he understands what's being stated here. So I have to set this for a hearing and request an interpreter.
Sounds good, Judge. You know, Judge, I think I'm in person tomorrow. I don't know if that's enough time. I'm there tomorrow afternoon at 2 in person. I don't know if that's feasible. If not, that's okay. I just thought I'd put it out there because I will be there in person tomorrow afternoon at 2 in front of Judge Ward.
Okay, no, it's not enough time for me to get an interpreter scheduled or to notify the defendant. Jean-Marie, can you hear us? I don't even know if he can hear us, so we would have to mail him a notice to appear. And then tomorrow, the court has a state docket and I believe scheduled for jury trial.
Okay.
So we will reset this matter. We can do February 13th at 1:30. February 13th at 1:30.
Thank you, Judge.
Thank you.
Do we want to do that in person or are you okay if we still Zoom?
I think in person might be the best because I don't know that he knows how to operate his Zoom.
I agree, Judge. Thank you.
Thank you.
Have a great day.
Thank you. So nobody's coming for sorry.
It's too cold outside.
But it's via Zoom.
Right.
It's too cold outside via Zoom.
You drive it.
Okay. Okay, on the record in the matter of Capital One versus Angela Winkle, 25-00165. Appearance for the record, please.
Good afternoon, Your Honor. Kelly Sheehy, P890882 on behalf of the plaintiff.
Your name, ma'am?
Angela Lewis.
Was it formerly Winkle?
Yes.
Okay, today was the date that was scheduled for a motion for summary disposition, which the plaintiff filed. Did you get a copy of that, Ms. Winkle or Lewis, Ms. Lewis?
It's okay if you say either one. I got this from them, but that wasn't anything I got from them, which was supposed to be for the last time.
I don't know what this is. What does it say on it?
It is, it was for the via Zoom one on 12225. It's like a whole.
But yeah, but there's in the middle some bolded letters that tells you what the document is. What does it read as?
It's a hearing motion for summary disposition.
Okay, so you received the motion for summary disposition. Did you respond to that motion?
I tried to. I've never used Zoom before. I tried to figure it out. Actually, they call up here and ask somebody.
Well, you would respond in writing.
Oh, see, I didn't even know that.
Okay, and I'm only asking because I don't see a response for you in the system.
Yeah.
Okay.
This is the first time I've ever dealt with something like this. I don't know what I'm supposed to do with stuff, so.
I'm sure. Okay, so there's a motion for summary disposition essentially stating that there's no genuine issue of material fact here. The court should grant their request because there's nothing that you provided during this case that would dispute the underlying debt. And I reviewed your answer. You're not disputing the debt. You're saying that you didn't have the way to pay it, correct?
I offered them, I said I would be able to pay $50 a month right now.
But answer my question first. You're not disputing the underlying debt. You were disputing your ability to pay.
Yes.
Okay, so in that case, their motion for summary disposition would be valid. There's not an actual dispute to what's going on. It's about how they're now going to get that money. For those reasons, and after reviewing the plaintiff's motion, and the court record doesn't reflect that you filed any response other than the answer, which the answer is not disputing the actual debt. I'm going to grant their motion for summary disposition. That will enter judgment against you for the amount that they say that you owe them, because you did not deny that you owed that money. You're denying your ability to repay it. And that does not mean that they can't get a judgment against you.
Right, I wasn't denying to repay it. I was saying I just can't.
Your ability is what I said. I said you were denying the ability to repay. Not that, that's all. You were homeless, you didn't have a way to, or you were unemployed for several months is what it says?
Yeah.
And so that's why you weren't able to make payments.
Yes.
And those are real life issues and real life concerns. Those issues don't negate the fact that you still owe the money, is what I was asking. And so the judgment can enter. Now you have to work with them to figure out how they can get their money.
Right.
Okay, you understand what's going on? Okay, so I think that there was an order provided as it relates to judgment. Is that accurate, counsel?
Yes.
Okay, and so you, ma'am, you did say that you were at the time unemployed. Are you employed now?
It wasn't at the time. I said I previously, when I tried to work with them, I had been unemployed for 3 months.
Well, that's what you said. You said at the time, you said I would pay because at the time I was not working and had no way to pay anything. So are you working now?
Yes.
Okay. And so you're able to make payments towards the debt?
I'm gonna try to.
Well, that's what we're here to find out. How much do you think you can make payments for?
What I originally said, about $50
a month. That's what you said?
And it would only be temporarily, and I would be able to pay them more later. It's just my husband just lost his job, so I'm the sole income coming in right now.
Okay, the reason why I say that is because while we're here, what we also can do is execute an installment payment order, ordering that you make payments of $50 per month.
Yes.
I can even set it for a review 6 months later to see what's going on with your finances.
Yes.
But if we get that installment payment order today, that will keep you from having to come back to court. I don't know if you had to take off work for this.
Yes.
So that you can file that later.
Yep.
And B, keep them from being able to garnish your wages because there's no payments going on. So do you want to do that?
Yes.
Okay. So counsel, are you able to execute that paperwork as well and file that through my file? She'll make payments of $50 per month in an installment payment order.
You want me to file the installment payment order?
That's what I'm asking.
Sure.
Because it can go, I'm gonna have you amend your actual order. It's gonna be granting the motion for summary disposition and entering an installment payment order.
Okay.
Where she'll pay $50 per month.
All right.
And so, when are you gonna make the first payment, ma'am?
It would be in 2 weeks.
She'll begin making payments, she said, in 2 weeks. 2 weeks from today
Yes.
is gonna bring you to the 27th. Okay, so you'll make it the 27th of each month.
Right around there, I get paid twice a month and it's different every month, but I will try to make it within the month. I don't know if I can set a specific day.
We've got to set a specific day for the purposes of the order. So we can say pay it before the 30th of the month.
Yes.
Okay?
Yes.
Okay. All right. So as long as the order reflects that, then I'll review and sign it. Council can file that through my file, okay? Do you have any questions?
Nope, that's what I wanted from the beginning. So when I first came here.
Thank you. Any additional matters for the record, council?
Nothing for me, Your Honor.
Thank you. You're all set.
Thank you.
Do I go anywhere for anything or
You're
will I
free to
get
go.
something in the mail?
You'll get, yeah, once I sign it, you'll get a copy of it.
Okay, all right. Thank you very much.
Booking flights online is
John Marie here. For the LT eviction, I wonder why it's on Friday.
Nobody knows.
Who put LT eviction on Friday? Oh, and I thought that one did an interpreter. That could be wrong. No interpreter was requested by civil, so it was supposed to be reset with an interpreter. And yeah, and I did the request. No one's here
No,
for either party?
always it. Well, I think Cox's office.
Oh. Who's on the phone number ending in 0150?
This is Paris Boyce of PDB Process Service.
Why are you calling into the courtroom?
We're calling on behalf of Eric Nzango.
Yeah, but why are you calling in and not dialing in with video?
Oh, I'm sorry. The landline is the closest thing is the only thing that's near.
Okay, well, we don't allow landline. Yeah, if you're gonna be a part of a hearing, you gotta come with video. I can't control the landline. And it causes, everything back on the background of your, wherever you are is gonna come through the courtroom.
Okay, is it any way I can get my testimony now? Because
You can't, no, you can't testify from a landline. That's the whole point. You got, if you wanna testify, I definitely gotta see you. I sent out Zoom instructions and none of them say that you can call in and give testimony. So I'm not sure, who subpoenaed you here?
this is, yeah, Eric Nzango.
You are Eric Nzango?
I'm sorry?
You are Eric Nzango or he subpoenaed you?
No, he subpoenaed me.
Oh, yeah, you gotta log in with the video. Mr. Nzango, are you here?
Yes, Your Honor.
You have to start your video as well. Did you subpoena someone to court today?
Yes, Your Honor.
Okay, well, they gotta log in virtually the same way you're logged in.
Well, that's the thing. We stand by the process serving.
I don't know what you think this is. This is not how this works. I'm not even on the record. You don't just start blurting out information. If you're going to, I'm checking people in. If you want to be admitted, and I've gone on longer than normal with this, you've got to log in with a video capability. You cannot dial in and give me any testimony on the record on a hearing. My only options for hearings is virtually with video or in person. Those are your two options.
Okay, guys, your car insurance company does not want you to know you can do this.
Big chunk.
Only thing is, Your Honor, we're out in the field right now, and there's no way we can get near a Zoom hearing. Yeah, we thought we could just call in.
That's unfortunate. That's not I didn't subpoena you here, sir. And I'm done having that conversation. Okay, let's see. Mr. Nzango, you might want to work that out if that's your witness. I'm gonna call the next case. It's LVNV Funding versus Kendra Stevens. Kendra Stevens here.
Good afternoon, Your Honor. Preston Nate, P77884, appearing for LVNV.
And good afternoon.
Counsel for Stevens.
Always it.
Yes, Corey Grandmason, P64392. I'm here for the Stevens.
Okay, thank you. Today was the date scheduled for pre-trial. Parties are represented by counsel on both sides. Did you all resolve this or work out pre-trial statement at all?
We are working it out, but in the meantime, we did do a pretrial statement. I'll get over to the court.
Very good. Anything that we should address while you're here on the record?
No, I don't think there's anything.
No, Your Honor.
Okay, thank you. Once I receive the joint pre-trial statement, you'll get a next court date in the mail, likely be for a trial date, okay?
Very good. Thank you.
Thank you, Your Honor.
Thank you. Thank you.
Honor.
Hi, you were here on the matter with Jean-Marie, correct? The eviction matter?
Correct, Judge, and we withdrew our request, but based on the timing that it was submitted, I did not know if the court received it yet.
We just noticed it, so thank you.
Okay, very good, Judge. Have a great weekend.
Same to you.
Thank you.
Well, that's going to be it for today, ladies and gentlemen. I appreciate the people watching after the fact. I really do appreciate the people who do support my channel. And it's like I said before, if you like this court content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel and help. Let's get up to the 500 subscribers before the end of this year. And I know we can do it. This is only February. I know we can do it. To all the new subscribers, again, welcome and thank you for support. So that's going to be it for today. Why is it not pulling up? Stop. There you go. Sorry about that. Yeah, but that's it for today. Ta-ta and ciao, and you all have a wonderful evening. I will see you guys back here tomorrow for Judge David Flesher. You all have a wonderful evening.
Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your album, standing tall, tall. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.